Let's talk about something that sounds, well, impossible. What happens when a court, the very symbol of legal power, issues an order it has absolutely no authority to make? It's a real thing, and it's all thanks to a fundamental but kind of hidden rule in our justice system. We're going to dive right into it.
So let's just ask it straight up. Can a court order, a piece of paper that carries the full weight of the law, actually be completely powerless from the moment it's written? The answer is a huge, surprising yes. And figuring out how that works, well, that's a total game changer.
All right, so here's our roadmap. First, we're going to look at where a court even gets its power in the first place. Then we'll see what happens when that power just isn't there. After that, we'll walk through a practical playbook for how to challenge one of these powerless orders. And we'll wrap up by looking at why this rule is so important.
Okay, so think of it like this. Every court needs a license to operate. It needs a foundational authority just to even hear a case. If you don't have that bedrock, anything you try to build on top of it is just going to collapse. And this power source, it has a specific legal name.
It's called subject matter jurisdiction. Now, this isn't just some technical term. It's everything. It's the court's basic power to deal with the kind of case that's in front of it. You know, you wouldn't expect a small claims court to handle a murder trial, right? It just can't. Without the right jurisdiction, a court is just a room full of people with no actual power. And trust me, the courts themselves take this deadly serious. A New Jersey court put it about as bluntly as you can. If jurisdiction is missing, all proceedings are nullities. What's a nullity? It's nothing. Zero. Zilch. It's like it never happened in the eyes of the law. This isn't some clever loophole, it's a core principle. And hey, this isn't just some quirky state-level thing. We're talking about the U.S. Supreme Court. They've been just as clear. In a case called United States v. Cotton, they confirmed that a problem with jurisdiction doesn't just make a judgment weak or flawed, it makes it completely void. This one really gets to the heart of it. A court just can't snap its fingers and give itself power it doesn't have. It can't just issue an order that says, poof, I now have jurisdiction. If that power isn't granted by law from the very beginning, no amount of judicial command, or fiat, can magically create it. So you see where this is going. If jurisdiction is the foundation of the whole building, and that foundation is missing, what happens to the building itself? What happens to all the orders in the judgments that came from that court? Well, you guessed it, the entire thing just crumbles. The legal world has a fancy Latin term for this, of course. It's void ab initio. And it means exactly what it sounds like, void from the beginning. This is so important. The order wasn't valid for a little while and then went bad. No, it was a legal nothing from the very second it was created. And this brings us to a super important distinction. You have to know the difference between a void order and a voidable one. A voidable order has a mistake in it, yeah? But it's still considered legally valid unless someone challenges it in time. But a void order, the one we're talking about, lacks that core jurisdiction. It's a legal ghost. It has no power, and here's the kicker. You can attack it at any time. Years later? Yep. Decades? You bet. So once a court figures out it doesn't have jurisdiction, its hands are completely tied. It has one job and one job only: dismiss the case. That's it. It can't rule on anything else. It can't hand out punishments. Anything else it tries to do is called ultra vires, another Latin phrase meaning beyond its powers. The only thing it's allowed to talk about is its own lack of power. Okay, so we've got the theory down. Pretty wild, right? But how do you actually use this information? Well, the source material for this whole explainer gives us a really practical playbook that anybody can use to actually take action. Let's walk through it. The playbook makes it super simple by breaking it all down into one filing package. You've got your notice of motion, that's just a heads up to everyone. Your certification, that's where you lay out the facts. The legal brief is where you make your argument. The proposed order is basically you saying, here, judge, sign this to fix it. And finally, proof of service just shows you played by the rules. It makes the whole thing way less scary.
All right, now we get to the really good part, the legal brief. This is the heart of your whole case. And the playbook boils it all down to 4 incredibly powerful, clear arguments. These are the knockout punches.
Your first argument is the most fundamental one. It's simple and direct. You're not saying the judge made the wrong call. You're saying the judge had no power to make any call. And because of that, every single order is void.
So here's how you do it. You state the rule. Jurisdiction is absolutely mandatory. Then the application. Since the court didn't have it, its orders aren't just wrong, they're nothing. And therefore, they have to be officially vacated, basically erased from the record, under the court's own rules for fixing these kinds of problems.
Now, the second argument kind of builds on the first one.
It focuses on anything the court did after it should have known it was powerless. You're essentially saying, not only was the first thing you did void, but everything you did after that was too.
The rule here is a straight line. A court with no power has only one legal move: dismiss the case. So your application is that any other stuff it did, like issuing sanctions or trying to enforce its own powerless orders, was ultra-virus. It was beyond its power, and so those actions are also totally void.
Okay, argument number 3. This one is a bombshell. This is where you might bring up an incredibly serious claim: fraud on the court. And yeah, it is just as serious as it sounds. This isn't about a mistake. It's about someone deliberately corrupting the whole process.
Now, what's wild about this is that fraud on the court has no time limit. You can bring it up whenever. Your argument is that if the other side deliberately lied or hid facts to trick the court into thinking it had jurisdiction, that action poisons everything that came after it, and all those poisoned orders have to be thrown out.
All right, the last argument. This is the practical one. This is the clean up the mess argument. It's not enough to just get an order declared void. You have to ask the court to actually reverse the real-world damage that was done. Think of this as handing the judge a to-do list. You're asking the court to actively undo everything. That means getting rid of all the penalties and fees. It means stopping any seizure of assets, those are called levies, and removing any legal claims against your property, which are called liens. It's all about hitting the rewind button and putting things back to exactly how they were before the court ever acted without power. So, why does all this matter? Why get into the weeds on this one specific rule? Because it's not just some cool legal fact. Understanding this is a massive tool for accountability. It's a way to make sure that our courts, as powerful as they are still playing by the rules.
And that leaves us with one final big question to think about. If a court's power really is like a license, with very clear limits, whose job is it to check and make sure that license is still valid? Well, as this whole playbook shows us, sometimes that person can be you. And that's a powerful thought.